Well, good morning, everyone. And this is Julie Stewart, Annuity Director here at the Milner Group. And I have with me today Warren Yancey, our Annuity Product Specialist on the line, along with Chip Anderson, who is the Executive Director for the National Association of Fixed Annuities. First, I want to thank you for taking time out of your day and joining us for an update on the Department of Labor's fiduciary ruling. The DOL ruling was passed in early April of 2016, and the launch date as it stands now is April 2017. Over the last few months, several lawsuits have been filed challenging the new ruling and seeking an injunction. So this morning, Chip Anderson will discuss the litigation and lawsuits that have been filed, what the outlook is, what we can anticipate as advisors, and really how everyone is responding, especially carriers. Should you have any questions during the presentation, please feel free to type them into the chat box on the right side of the screen, and hopefully if we have time, we will answer them, and if we don't, we'll reach out to you after. So Chip, we do appreciate your time this morning, so without further delay, take it away.
Thank you very much, Julie. I appreciate the opportunity to be with you today, and thank you all for dialing in to get some updated information in regards to this issue that we've been dealing with for a long time in regards to the Department of Labor. As many of you know, there's been a lot that's been written about this. I see 6 or 8 articles a day from a lot of different sources. Some of that information is accurate and some is not, so we'll try and give you as much information to keep you updated on the accuracy of what's going on. As Julie mentioned, there's been a number of different lawsuits. We're going to touch on that. We're going to touch on a meeting that NAFA just had. But the real key certainly is the Department of Labor issue. And as many of you know, when it was released a year ago in April back in 2015, it was 250 pages. Now the new rule, after they've made some changes, is over 1,000 pages that was just released in April of this year. And with their sense of humor from the Department of Labor and from the current administration, they said they made it simpler, which is really interesting, going from 250 pages to 1,000. But let's get right into it. So next, we've got a disclosure page there on the next page, and just for you all to understand that anything that is said on this, you know, that you can't come back against NAFA arising out of the use of this information. And mainly if I say anything about the current administration or the federal agencies that might offend anybody, we certainly don't want that to come back and against NAFA. So let's get started. Next page. We had an annuity leadership meeting, the largest meeting that we've ever had. Certainly that was due to the Department of Labor ruling. Everybody wanted to be there to have their voice heard in DC. We have this meeting every year in June in Washington, DC. And this year we had 125 of the NAFA members attend the two-day meeting. And we had some great presentations from senators and congressmen regarding the Department of Labor rule and other things that are going on. Although we're focused on the DOL rule, that's just not all that's going on in our industry and with current legislation. We had a hill walk, and the reason I'm going through this is to make sure if you all have not done this before, this is certainly a tremendous opportunity for you to go to DC. NAFA handles basically all the arrangements as far as setting appointments, but you get to go and talk to your senator or congressman and share your thoughts with them in regards to what's happening in our industry. We also had a panel presentation on the Department of Labor ruling from the attorneys that were involved with the suit that we have hired in DC. The law firm is Bryan Cave, very well-known law firm in DC, and attorneys from carriers, attorneys from marketing organizations, and the NAFA attorney that we have, Pam Heinrich, who has been directly involved in this. We had a 1-hour panel discussion where people got to ask questions and go through in detail the Department of Labor ruling and what the current status was on that. So lots of great information. Next. These are a couple of the people that actually spoke. Congressman Phil Rowe from Tennessee, Congressman Blaine Lukemeyer from Missouri, Senator Johnny Isakson from Georgia, and then our keynote speaker was Jeff Bush, no relation to the other Bushes, but Jeff Bush did a very powerful presentation on the Washington update, giving us information in regards to the key issues during the election, the two final candidates that we have running on the Democratic and the Republican side, and then also a lot of insight in regards to how voting has been swayed in the past. Very good information for us to share as we came back home with a lot of the things that we're working on. Next. Couple of pictures there from some of the events that we had and some of the speakers, some of the senators and congressmen there. Next slide. And some of the groups attending the offices on the Hill of the Senate and the congressmen that they visited. This is a great opportunity, as I said, to not only get your voice heard, but to see the insights on how some of these things work in DC, and presenting an issue to your representative and actually getting them to listen, or their staff members, as it is in many cases. Many times you don't get a chance to see the senator or the congressman because they're in session, but you get a chance to talk to their staff members who are the ones that are actually working on the programs. Next. Let's jump right into the lawsuit in regards to the lawsuit that was filed. And as I mentioned, we'll touch on this a little more. There were other lawsuits that were filed in different areas. NAFA's lawsuit was filed on June the 2nd, and we filed in Washington, D.C. NAFA's headquarters are in Washington, D.C., and we felt that was our best bet with the law firm that we hired because they are also in D.C., and the case would probably be heard there by one of the judges in the district court. So we filed in D.C., and there's 6 claims that we had, and I'll touch on these so that you understand the basis of our lawsuit. Number 1 is that the Department of Labor, DOL, exceeded their legal authority in expanding the definition of fiduciary to include insurance agents who sell fixed annuity contracts. That's really our main concern. And in doing this, they abandoned the time-tested 5-part test and expanded the definition of who is a fiduciary to include insurance agents who sell fixed annuities. That's well beyond the scope of the definition of the fiduciary. And the DOL provided no rationale for this unprecedented shift to assign fiduciary status to insurance agents. They've never been thought of fiduciaries in any context. And this law goes back to 1975, the ERISA guidelines on the common law of trust. Even the DOL conceded that this, was a broad test that could sweep in some relationships that aren't appropriately regarded as fiduciaries. And so, they overstepped their bounds, quite frankly, in this and trying to put everybody in the role as a fiduciary. Number 2, the DOL exceeded their legal authority to impose ERISA fiduciary obligations to parties involved in IRA transactions. This is a little background for you. ERISA does not authorize the DOL to impose these fiduciary standards on IRA advisors, people who advise people on their IRAs. IRAs are not covered by the ERISA guidelines. The IRA transactions are governed by the Internal Revenue Code, and only the code provides that the DOL, and the code only provides that the DOL can regulate certain circumstances under which an excise tax could be imposed on an IRA advisor for engaging in these transactions. So they can't do what they're trying to do basically as far as IRAs. That's the simple answer to that. Third key point is the DOL exceeded its legal authority in creating a private cause of action under BICE, under the BICE guidelines. Only Congress can do that. Only Congress can create a private cause of action. Now, for those of us that are lawyers and attorneys, a private cause of action basically means the ability for the people who do something that doesn't follow the BICE guidelines to be sued, which is really the main concern that we have in protecting the advisors out there, and certainly protecting the carriers and the marketing organizations too in regards to what might happen. Neither ERISA nor the code authorizes the DOL to create a private cause of action for any breach of fiduciary duty. Only Congress can allow or create what's called a private right of action. Next slide. the definition of reasonable compensation is another key part, and it's so vague that it violates the due process clause under the Constitution. The rule is so vague that, saying that you can only pay a reasonable compensation with no guidance on what that term means is just flat out wrong. The rule doesn't provide any meaningful standards with all the 1,000 pages that are involved in it. Doesn't provide any meaningful standards for those that will ultimately determine what is reasonable compensation. And they leave that up to the state court judges and the juries under what would be the private cause of action getting sued on this. There's no really a reasonable opportunity to know what reasonable compensation would mean. So ultimately, we think this makes the rule void for vagueness under the Fifth Amendment due process clause. You can't just throw something out there with no guidelines, and that's exactly what the Department of Labor has done. So on the next point, the next one is the last-minute switch to put fixed-indexed annuities under the BICE guidelines and to treat fixed-indexed annuities as security products, which is contrary to the law and really unworkable in that regard. So that's a consideration for us. And the positioning of fixed-indexed annuities as securities is contrary to existing federal law under Dodd-Frank. BICE was designed for the securities industry and not for our industry, and our business model to distribute the fixed index or the fixed annuity product. The next key point is the Department of Labor failed to conduct an adequate business impact analysis as required under the Regulatory Flexibility Act. There's nothing in the DOL rule to demonstrate that consumers have been harmed in any way by the purchase of fixed indexed annuities. So that's a consideration. And on the contrary, consumers, and especially those with IRAs, have been extremely well served by the conservative nature of the fixed annuity products in times of market unpredictability. And we've certainly seen that just recently with what's happened in there, with what's happened in Europe and how that affected the U.S. market the last couple of days. So that's a consideration. Those are the key things that we have as far as the points in regards to the guidelines for our suit. Next slide. Additional suits that were filed against the Department of Labor. There are 5 total suits. The first one that was filed June 1st was the U.S. Chamber of Commerce suit and others in the U.S. District Court in Texas. The one from NAFA, our organization, was filed on June the 2nd, and that was filed basically in D.C. Also on June the 8th, ACLI, the American Council of Life Insurance, was filed in the U.S. District Court in Texas, along with the Indexed Annuity Leadership Council, IALC, a small organization with a few carriers there. On June the 8th, Market Synergy Group also filed in Topeka, Kansas. Market Synergy Group is a group of about 15 different organizations that are marketing organizations, and they market a specific product or proprietary product. So they filed in Topeka. So you have 3 suits that are being combined in the U.S. District Court in Texas, the NAFA suit in D.C., and the Market Synergy Group, MSG, in Topeka, Kansas. The 3 Texas suits have been combined. They'll hear all those together, but they don't look at this point in time to combine all of the other suits that we have doing it. Many of these suits have similar aspects, but the NAFA lawsuit has filed for what's called a preliminary injunction. And the preliminary injunction asks for relief immediately, saying that all of the people involved in the sale of fixed indexed annuities have been harmed, and the longer this goes, the more there will be harmed. Let me give you a little insight in regards to the timeline for our suit, the NAFA suit. Next slide, please. On July the 8th, the government will have this date to file its brief. Remember, we filed on June the 2nd, so they've got about the first 30 days. The government will have until this date to file their brief in response to our lawsuit that NAFA filed and a cross motion for summary judgment. On July 22nd, NAFA will be granted the opportunity to reply to their response in the cross motion, and then our brief will be due at that time. August the 1st, the government will provide an index of the administrative record, just administrative stuff. The government's final brief is due a few days after that on August the 5th, and then all the parties are to provide updated citations to the administrative record, but we can't make any other changes as far as things go along. This is just a process in regards to how this suit moves down the line. But August 25th is the date that the hearing will actually be held in DC with the judge. There's no jury trial here. It's just a hearing by the judge to hear his points on it. We have a very good judge in DC, and he's very competent, very smart, and knows the law very well, which is probably helpful as far as our case is concerned. After that hearing, which will be in DC for that, along with our attorneys, and we'll be in the courtroom there. After that hearing on August 25th, then there'll be a final determination, and we think sometime in the month of September that we will hear a final determination on our suit, maybe by October the 1st. We are on a faster track than the other lawsuits that have been filed, the ones in Texas and certainly the one in Topeka. And so that is good for us because we're moving forward, and we think that all the information that we have in our lawsuit is very, very good to make a very positive case as far as the industry is concerned. We're not looking just to fix this as far as our organization or for fixed indexed annuities. We're looking to fix this for the entire financial services industry. So that's a key point that I think is important for you all to realize. Next slide. Here's a little update in regards to what's going on the Hill, because we have the lawsuits, but we also have legislation that's being worked on too. There were some bills that were put forth. Rowe and Roscom, and Phil Rowe, as you might remember, spoke to us when we were there in DC at our meeting, and also Johnny Isaacson, who is one of the key people on the Senate bill. So it's important that we actually heard from those people that put forth some of the legislation to try and stop the DOL rule. With this, President Obama vetoed this, and it went back to the House, and really we didn't have enough votes to overturn the President's veto. Again, this is, the DOL rule is clearly something on the agenda for this current administration because he wants to get this done before he leaves office. So that's the challenge that we have in front of us. Next slide. So this is the question that we get all the time. What can I do to help? And certainly NAFA has a litigation fund. With the lawsuit that we have pending, it's a long and expensive process. And NAFA, as the organization that we are, a not-for-profit organization, did not have the funds to do that. So we're asking and accepting contributions to the NAFA litigation fund. There's still a lot of work to be done on the legal front, and it's critical that we get your support by donating to the Legal Action Fund. Any amount would help. Certainly the carriers and the marketing organizations have put forth some money, and we're grateful for all those people that have contributed. We thank you. If you've already contributed, we appreciate that. Second, make sure that you stay on top of the issue. Stay updated by going to the NAFA website, and you can do that, and we post a lot of things there on a regular basis. As I said, there's articles every day on this issue, and they're from both sides. Some are pro and some are con. But sometimes those articles aren't necessarily accurate in regards to what's going on. Third, if you weren't able to join us in Washington last week, you can do your part by a NAFA virtual Hill Walk. We put this together where you can send your thoughts to your senator or congressman, and we've made that very easy. I'll show that in the next slide in just a minute. But we've created a packet of materials that summarizes NAFA's key positions on the issue and contains educational materials for you that you can use to get to your elected officials. Many of them are heading home for a break, and you can actually see them if they come back to your local city and spend some time with them there. That's extremely important. And last thing is you can contribute to the conversation on NAFA's LinkedIn page and Twitter using the hashtag Annuity Leadership, and expand our thought leadership to those outside of our industry on just how much this is going to harm, you know, the entire industry. Next. Here's the page in regards to some of the materials and information on the virtual Hill Walk, and you can go to the NAFA website and download this information. And you can also find, if you're not sure how to contact your elected officials, here's a website there that you can find information on your local elected officials in regards to your area, and that's right there at BIPAC, capital BIPAC.net/NAFA. Next page. If you have some questions that aren't answered now at the end of this webcast, you can certainly email me. My email address is very simple, chip, C-H-I-P, @nafa.com. We're always happy to help you and help our members in any questions that they might have. Next. NAFA is your voice, and to protect the industry, we work on your behalf 365 days a year. I'm in Washington, D.C. a lot, other than just the time that we have our meetings, meeting with people on the Hill and working with different trade groups to get our voice heard. And if you're not a member of NAFA, we certainly would like you to go to the NAFA website and join and be a member to get all this information for you. We might take questions now at this point in time if there's some questions that came in.
Okay, let me give folks a few minutes to type something out if they have any questions.
And I think it's good, you know, that we've seen, Chip, and thank you for sharing where we stand today with the fiduciary ruling and really what's being done to try to curtail it. It definitely sounds like the lawsuits clearly point out the ambiguity of the legislation and really why it should cause it to be thrown out. So I think that it's very positive. You know, and as always, we're going to continue to keep all of you updated as to, you know, how this unfolds over time. Warren, do we have any questions?
Yes, we have a few. So one question is, how are carriers reacting to this rule, and how do you expect them to adapt?
That's a very good question. Carriers are looking at this very closely, and as you can imagine, the 1,000 pages, with all the people that the carriers have, they're still sorting through a lot of this to see what they have to do. There's a guideline in here where the carriers and a couple of other groups, banks, broker-dealers, and registered investment advisors are the only ones basically that can sign the BIC or the VICE contract. That's a concern because that creates liability. And while the carriers are hesitant to do that, they're only hesitant because when they sign that contract, that puts them right in the crossfire of being the first group that would be sued if a client or someone is unhappy, or if an attorney thinks that something was done wrong, a registered rep or somebody who sold a product wrong. And the liability that that creates, not just for the individual agent or the registered rep, but for the carrier, is tremendous. It's basically, and these are my terms, but it's basically open season on anybody who's in the financial services business, because attorneys could say, well, you sold the wrong product to my client. You should have sold this product. And frankly, if you analyze it, almost anybody in their business could look at something and say, oh, they shouldn't have sold them that mutual fund. They should have sold them the fixed annuity. Or they shouldn't have sold them that fixed annuity. They should have sold them the mutual fund. We know you can make a great case for all the different products out there. It has to do with what's the best fit for the client. And that's very vague and very up in the air in regards to who decides that. Are you going to let some court decide what was best for the client? That's the reason that the carriers are looking so closely at this and trying to determine if they can even comply with what the Department of Labor is telling us that the carriers and the distribution and the individual agents and registered reps have to do under this. Very onerous in regards to that. Senator Johnny Isakson said they took 1,000 pages to describe the fiduciary guidelines. 1,000 pages to describe these guidelines. So that's why the carriers have to look at this so closely and analyze what they're going to do as far as distribution of these products going forward.
All right, that's good info. So the other question we had was, what does this mean particularly for independent insurance agents that are operating in the fixed annuity space?
Very good question. Certainly, if they sell fixed indexed annuities, because they have been moved over from the 8424 exemption, which we've had and worked under for a number of years, for 30 plus years, they've been moved over. If you're selling fixed indexed annuities, they've been moved over to the BICE guidelines and treated like a security. However, going forward, if the carriers and the distributors have to comply with these guidelines, this only applies to qualified money as we know it right now. But going forward, if everybody has to apply with these guidelines for qualified money, it would make sense that they look at this with a broad brush and apply these guidelines for qualified and non-qualified money. So ultimately, in my opinion and many of the experts' opinions, we think that everyone is going to have to fall under these guidelines. Traditional insurance agents who sell non-qualified money products or non-qualified annuity products ultimately down the road will probably be thrown into this. They're not now. This is only for qualified money now under the ERISA guidelines that the DOL is looking at. But ultimately, everybody will probably have to file these rules. It's up in the air right now as far as how these things are, but many carriers are not going to have two separate standards, and many broker-dealers on the security side are not going to have two separate standards for qualified money and non-qualified money. Again, that would just be open season for attorneys to come in and file lawsuits against those people who sell the products. Well, you did this for their qualified money, but you didn't do this for their non-qualified money. It doesn't make sense. So that's still up in the air in regards to how some of the individual insurance agents are going to be handled. But in all likelihood, looking down the road, everybody is going to have to fall under the same guidelines ultimately.
So if carriers are not really interested in taking on the fiduciary responsibility because it would just be so much to bear, do you think that ultimately distribution will go direct to firms that already carry that title, such as broker-dealers or RIAs, and maybe the independent distribution channel?
Right. And we think because of the guidelines that the Department of Labor has set forth and some exceptions that they've made, there might be more of a trend, and I know this sounds funny for all of us who've been in the business, there might be more of a trend to go back to captive agencies that sell a particular line of products, because those people actually had an exemption that were made like a, I don't want to use this term, but like a company that has a captive agency. I'll use it in the property casualty like an Allstate or a State Farm, because as was explained to the Department of Labor, these guys can't go out and sell all the different lines of products, so they're not able to show their clients a complete range of products. They're limited as far as being a captive agent to only be able to show and sell those products that they are authorized to sell from their particular company or carrier. So the trend might be to go back to that, and many of these companies who are distributing products might say, okay, we'll let you sell these products and we'll sign off on the BIC guidelines, but you can only sell our products. You can't sell products for 10 different carriers. You can only be captive and sell products with our carrier. That's one solution that they're looking at in order to get around some of the guidelines. Doesn't seem to make a lot of sense. That's not what the purpose is, and that's not in the best interest of the client, as we all know. But the liability, company A can't make sure that the agent is doing the right thing by selling company B or company C's product if they don't know what that product is and don't know that he's selling that product. So it's hard for them to know that he's doing everything in the best interest of the client when they can't even control other carriers' products or what those products are or if he's selling them or not. So if they say you can only sell our products, and if you don't sell just our products, we can't help you, basically is what that means.
Warren, are there any other questions? Yeah,
frustrating, isn't
it
it,
is
folks?
frustrating.
It looks like those are all the questions for now. Again, feel free to reach out to us after this. If you guys have any more questions, you can always email myself or Julie. But that is it for now.
Okay.
Excellent.
Thank you all for your time, and thank you for your support. And please, if you can help us in our efforts to defeat this DOL rule, we would certainly appreciate by you joining NAFA as a member and by you helping to support us in regards to our legal efforts with the Department of Labor.
Great. Thank you so much, Chip. And everybody have a successful day. We'll be in touch soon.
Okay. Thank you all.
Bye-bye.